I'd like to begin today by acknowledging the Tasmanian Aboriginal people, the traditional custodians of the land that we meet here today, and pay my respects to elders past, present and emerging. I'd also like to extend that respect to any Aboriginal people that are here with us today. My name is Todd Kennedy and I'm the CEO of the Public Trustee, and I'd like to take this opportunity to welcome everyone here today in the first of a series of seminars that the Public Trustee is running around the state as part of Seniors Week. We're a proud sponsor of Seniors Week this year, and I'd just like to say that the work that CODA Tasmania has done, Council of the Ageing, in pulling together this year's agenda has been fantastic. And I just thought I'd give a shout out to David Rose and the team for giving us the opportunity to be part of it today. Before I kick off, I do have a couple of housekeeping issues that I'd like to cover off. The presentation itself will run for about 40 minutes. You'll be pleased to know, though, I won't be talking for that whole time. I'll share that with my colleague Rod, who I'll introduce shortly. And after the 40 minutes, we'll have some time for questions and answers. And we'll finish up then with some morning tea. And I'll be sticking around with Rod and the team for anyone who wanted to ask some questions of us directly then. Also, if you're not familiar with the venue, the bathrooms are out the door, down the corridor and on your left. And in the unlikely event of emergency, it's every man for themselves, as I say, but the main exit that you come in is the best way to exit the building. Okay, so I just thought I'd spend a little bit of time introducing myself and then my colleague Rod. So I started with the Public Trustee back on the 17th of January. Prior to that, I was in wealth management and trustee services for nearly 21 years with MyState and Tas Perpetual Trustees, which is now known as TPT Wealth. And I was really excited about the opportunity to take on this role to lead the Public Trustee, especially when it was at such a critical point of change. I've got a real passion for clients, and regardless of what role I've been doing in the past, one way, shape or form, it's always been dealing with people. And I pride myself on building businesses that are based on doing the right thing and trust. I'm also a really proud Tasmanian. I've always worked here, and I thought what a great opportunity to continue to bring up my family here in our island state. So that's enough about me. Over on my right, sitting at the front, is Rod Clifford, who's the Manager of Risk and Compliance at the Public Trustee in Tasmania. And Rod's role requires him to oversee our people, ensuring that they're complying with our policies and procedures correctly. He also implements programs to ensure our staff safety and well-being. The name Clifford is synonymous with hockey in Tasmania, and Rod's been a champion hockey player over the years. I think he wrote that into my speech today. But he still likes to participate with hockey and also soccer. Rod and I have got a couple of things in common. We used to work together many years ago at Tasmania Perpetual Trustees. And for full disclosure, for everyone in the room, we're both one-eyed Collingwood supporters. So now's your time if you need to leave or... Okay, so let's get started. I just wanted to point out that today's information is general in nature. Rod and I are not financial advisors. We're not experts in aged care, and really everyone's situation is so different. So just wanted to remind people that it's high level today, and we'll do our best to answer everyone's questions, but it is general in nature. So someone asked me before we kicked off today, they said, look, there's been a fair bit of publicity about the Public Trustee in recent months, and was I going to spend any time talking about what's happened? And absolutely, that's the first part of the session today. I also wanted to talk about the services that we provide in the community. And that's before we move on to the big topic, which is really about the importance of planning ahead. And it's about what documents you need in place to make your financial, medical and legal wishes known. And at the end, we just want to share some of our experiences when we're working with our clients around the move into aged care. And as I said before, If you want to have questions along the way, pop your hand up, but we'll also have some time at the end. So the public trustee, unlike myself, who's only been here since January, has been around for generation after generation, dating back to 1915. And when it started, its main purpose was really around providing specialised wills, estate planning and trustee services to the people of Tasmania. And the fact that we've been around for generation after generation is something we're really proud of. But over the years, our role has changed, and it's evolved to, I guess, fill a bit of a gap in the community for the growing needs of that community, in particular with the ageing demographic that we have here in Tasmania. The public trustee offers a range of free services to the community or subsidised services, as well as our full paying services. So let's have a look at some of the main things that we focus on. So we prepare and give trusted advice when you make a will. We prepare enduring powers of attorney, and we also act as attorney when appointed to do so under one of these enduring powers of attorney. We prepare enduring guardianship documents, although we don't act as the guardian ourselves. We administer deceased estates when we've been appointed as the executor under a will. This is a really big part of what we do. And the public trustee can also assume the role of executor if the person named in the will is unable or unwilling to do so, providing we have the consensus of all the beneficiaries. We also act as a trustee for various trusts. These could be accident compensation awards, criminal injuries, or minors' trusts in the unfortunate event that parents have passed away. We manage money as well and manage funds under our control, and we do that really well. Again, something we're proud of, providing a commercial rate of return for our clients, most importantly protecting their capital, but making sure that it keeps pace with inflation over time. More recently, in the last sort of 20 to 25 years, we've also taken on the role assisting people to manage their financial affairs when we're appointed as financial administrator by the Tasmanian Civil and Administration Tribunal, or TASCAT as it's known. Some of you may recall it was previously known as the Guardianship Board. So what are the reasons that people choose to do business with us? Well, it's our expertise against what is a very complex area, and there's a whole range of different areas that you need that expertise in. So it's quite a burden for people, if they're appointed executor, to pick those responsibilities up for themselves. Our independence is also a big thing. Unfortunately, in this day and age with blended families, when there's money involved and grief, it can actually be a really difficult time for people when money is involved, and families choose us to have an independent person to actually help guide through and make sure their wishes are followed and try and take the pain out of that for families. But it is a challenging role, I'm sure you can imagine. And the last one is our longevity. So people often have relationships with solicitors during their life, but solicitors retire, they come and go. One of the things that attracts people to the public trustee is that we're an organisation, and an organisation that will be here in the future with over 100 years track record. So let's have a bit of time reflecting on the independent review that was conducted last year. Just a bit of a show of hands. I assume everyone is aware. Put your hand up. Yep, a lot of nods around there. Anyone not heard of the review? No? Excellent one. Okay, well, we'll cover that off. So last year, the Tasmanian Government commissioned an independent review into the administrative and operational practices of the public trustee. And Damien Bugg was appointed to do that review. And Damien made 28 recommendations out of that review. And most of those recommendations related to our financial administration service. So this is the part where we're appointed to look after people that don't have any documents in place, no power of attorney in place, and the Guardianship Board then has a look to see if there's anyone that can look after those people, and if there isn't any, as a last resort, the public trustee is appointed. So that was a big focus of the review. So we welcome the review, we accept all of the recommendations, and it's really an opportunity for us to take stock of our current practice, look at ways that we can improve our services, in particular when it comes to looking after some of Tasmania's most vulnerable people. So in Tasmania, as I said before, if you haven't prepared your estate planning documents, and Rod's going to talk about the importance of that today, and you have an impaired capacity to make your own financial decisions, this could be an age-related illness, dementia, sadly, is a common one, or it could be a mental incapacity, could be as a result of an addiction. Often they're really sort of problematic and complicated things that are going on with people's lives at that point in time. And the third thing is there anyone who fits the criteria to assist that person to manage their money? TASCAT, or the tribunal, as I mentioned before, can then appoint the public trustee if there isn't anyone else to do the role. And they do that under a financial administration order. So we don't have any say as an organisation as to whether that we accept that order or not. We're there, the government puts us in place as that safety net for Tasmanians. We're not out there promoting ourselves, we're not out there trying to attract business. We're there when the tribunal appoints us, when they deem that that person doesn't have anyone else suitable. Now sometimes they'll also appoint a guardian. Now the guardian deals in non-financial matters. It might be the person's accommodation, for example. Do they need to move into a home? They're not matters that we deal with. The public trustee deals with financial matters. Now a guardian can sometimes be appointed for a short period of time, or sometimes there's no guardian at all. But sadly, without any intervention, these clients don't have anyone else to help them at what is a really challenging point in their lives. So the legislation at the moment is the Guardianship and Administration Act of 1995. It sets out the powers and the duties as a financial administrator. So the law actually states what, if it's the public trustee, what we can do and how we actually have to go about administering an estate or looking after someone's affairs. I think a good practical example is during the review there were some examples where it was reported that people needed money for Christmas presents and the public trustee wouldn't release those money. When an order is handed down to us, it actually sets out what we can and we can't do as far as spending clients' money. And a lot of the time, the tribunal will say that there is no money for gifting. So if there isn't any money for gifting allowed under the order, again, we don't actually have a say in what we're allowed or not allowed to do. And often they will do that because they're concerned about some sort of elder abuse for that client, or they have very limited funds to make ends meet from a day-to-day point of view. So a lot of the time the public trustee is really following what the Act and the order says we can and we can't do. One of the recommendations that came out of the review was that government needed to review this legislation, and you might have seen in the last sort of week or so, the government has released a draft bill making some changes to the current legislation. This was actually recommended a number of years ago by the Tasmanian Law Reform Institute, and as part of the review, the government's now making changes to that legislation. It's currently open to the public for consultation, and that period is open until the 28th. So if anyone has an interest, then I would encourage you to have a look at the legislation and provide your comments. What's our view on relation to the legislation? Well, that is a matter for government and the Parliament. However, anything that is a benefit to the clients that we look after, that are vulnerable, we're supportive of. Our priority has always been to protect and have oversight and look after the client's well-being, and we'll continue to do this. However, the review process has highlighted that we need to do better. There were some cases where clearly we hadn't met the expectations of clients or the community, and we simply need to do better. And we're really committed and working hard to making the necessary improvements where those areas were highlighted. Some of the things that came out of it was around just having a bit more empathy at times with clients or listening more, being more accessible. So our services for these clients were centralised in Hobart, but we've just put on some staff in Devonport and Launceston because during COVID, one thing that we did learn from our clients is that they still value, like I guess many people in the room, that personal face-to-face service. So that's something that we're working on at the moment and very proud that we've put in place. So I just wanted to touch on some of the responsibilities that we perform for people when we're appointed to as their administrator. It's making sure bills are paid and debts are paid, checking that our clients are receiving the right income. So that could be reviewing their Centrelink entitlements. A big part is protecting their financial well-being. And unfortunately, a sad reality today is that elder abuse is on the rise. The statistics are that 1 in 6 people are subjected to elder abuse. But underneath all of that, it's believed commonly that the numbers are quite higher. Can anyone sort of hazard a guess as to why we think those numbers are a lot higher when it comes to reported elder abuse?
Too scared to report?
Yep, absolutely. The really, I guess, alarming thing is that it's quite often the adult son or the adult daughter that is the perpetrator of the elder abuse. And so therefore people are really reluctant to actually raise these issues because it involves family. So our role is to, as you can imagine, we're often in between these situations, and it's a really challenging way to navigate our way through. But our role is to look after the client that we've been appointed to and to always act in their best interests. The other thing we do is help prepare a budget in respect to the client's wishes and personal goals. And I'll talk about this a bit later, but one of the sad realities about moving into aged care is that for clients that are living on an age pension, after all of your fees are taken into account, there's not much left over from fortnight to fortnight. So we try and work with clients as best as we can to make ends meet, which is with not a lot of money, sadly. Another part of our role, which we're focused on doing a lot more in this space, is encouraging and supporting people to get back on their feet and take control back of their finances. Things like dementia, for example, the prognosis is not positive, let's be honest, but we think that our role can be about prolonging someone's capacity, not just about maybe restoring it, but what can we do, giving some responsibility to people. It might be them paying some bills each week or taking on some of those tasks that they used to do to try and prolong that capability. One of the things that I'm focused on since joining the Public Trustee is to bring our caseloads down for our staff. It's a really special type of person that works in this role, as you could imagine. And we want to make sure that the caseloads are down, especially with the changes in legislation, because people just need the time to get to know their clients outside of their finances. It's easy to sort of, be caught up in the whole email and, life gets busy, but we need to get our caseloads down for our staff so they can spend the necessary time getting to know the clients we've been appointed to look after. Also, there's a lot of conversation around giving clients a voice and whether they have the ability to have a say about certain issues that are happening in their life. One of the things I'm most proud of since joining is the work that we've done with our clients and stakeholders over the last 10 months. We've set up client and stakeholder reference groups, and we meet every month. And this is a great opportunity to work on our future services, to get direct feedback around what does it need to look like. And on top of that, I've also made myself personally available for any clients or families or organisations or advocacy groups. If there are any individual cases that need quick attention, they have my direct number and our staff is there ready to resolve them as quickly as possible. So as far as the progress was made in relation to those 28 recommendations, we're working really hard. We've made good progress. We've implemented successfully 13 of the 28, and there's another 12 that are well underway. And we'll be focusing really hard over the next 12 months to implement all 28 recommendations. But the work won't stop there. It'll then become part of the normal course of business, continuing reviewing the things that we do, talking to stakeholders, talking to clients about what we might need to do differently. And I look forward to providing updates in the future, whether it be via these sort of events or something on our website or any of our social media channels. So just as I wrap up before I hand over to Rod, another part of our role here at the Public Trustee is to provide education and information to Tasmanians and the community to encourage them to plan for their future. I just spent a lot of time talking about a group of people that are in a certain position because they haven't planned ahead and they don't have the documentation in place. So we're encouraging people to make sure that you've got your will, your enduring power of attorney, and your enduring guardianship in place. By providing seminars like today, we hope to raise the awareness and understanding and the urgency around how important it is to plan ahead. So, on that note, I'll now pass over to Rod, and he'll start to delve into the big three, as we call it.
Thanks, Todd, and once again, welcome everybody. And can you hear me clearly at the back there? Good. Okay. As with any presentation, Maria prepared some notes for me, which I duly threw out this morning, and I'm going to ad-lib and go through my presentation, and in about 15 minutes we'll find out whether that was a wise move or not. I'm going to briefly cover over about 15 minutes what I've personally witnessed and experienced over nearly 30 years in the industry, and I'll be concentrating on the three areas of enduring power of attorney, enduring guardian and will, and in each of those basically covering four questions: what, why, how and who. Hopefully to give you some information that you can then go away and make some informed decisions yourselves as to what way you're going to progress. At the end of the presentation, I'll ask one question, and that's when. When should you do all this? So, having said that, enduring powers of attorney, what are we talking about there? An enduring power of attorney is the most powerful document you could ever sign. Once registered, that document allows whoever you appoint to do whatever you can do yourself with regards to your financial circumstances. They can sell your house, they can call in your investments, they can go off and invest in Bitcoin, anything. So why would you have it? The first thing I think of as well, it avoids you going to TASCAT and avoids a financial administration order. The power of attorney allows you to appoint someone that you trust, whether it be an individual, a group, a solicitor, a firm such as ourselves, to control your financial circumstances and your welfare into the future at a time when you're unable to do it yourself. It can also operate in times if you're absent from Australia or the state or on holidays, whatever the case may be, and you need some financial decisions to be made on your behalf whilst you're away. So it can be a restrictive document for a specific purpose, or it can be a general document which looks after everything. The documents we prepare are general documents where it gives a broad range of powers to the individual. Okay. How do you prepare these documents? It's a legal document. It's in a legal format, and there are legal requirements that must be met. So if you're going to prepare one, go to a solicitor, go to a trustee company, have it set up for your purposes and have it executed in the appropriate manner. Then make the decision as to whether you wish to make it registered or not. Because as I say, once it's registered, you're handing over the power and ability of the individual or the individuals to make decisions for you on your behalf. Think of who you would want to appoint. You can appoint an individual attorney, as I say. That person goes off and makes the individual decisions for you. But what if that person's no longer able to do so? Think about who the replacement would be. You can name joint attorneys who can act jointly or severally. The problem with naming joint attorneys is if you have two, the second person is bound by the decisions of the first person. So you can have one person actually going out and making decisions and the second person not involved, but being liable for those decisions. You could have a solicitor involved, which is fine, but as we know, solicitors' firms do change. Solicitors do things on occasions that they shouldn't be doing and are held accountable for. And you can name a trustee company such as ourselves or Tas Perpetual or TPT Wealth as they are now known. Give some careful consideration to naming individuals. From my experience, I've seen situations where opportunity presents temptation, and family members, for best intended purposes, do take advantage. And we have that word or that phrase, elderly abuse, creeping into society more and more now, where family members do take advantage of elderly parents. And I've had it said to me, Mum doesn't need the money. As Mum's sitting in the aged care centre, aged care to home with one TV, one chair and one bed, and the kids are taking every opportunity to use the funds, travel overseas, put the kids through private education and so forth. So just be aware that opportunity does create temptation, and temptation can lead to problems. What if you don't have a power of attorney in place and you lose capacity? Because all what I'm talking about today is things that you can do whilst you have the capacity to do so. You have the mental capacity to make decisions for yourself and you understand what you're doing. If you lose that capacity and you don't have a power of attorney in place, then any interested party, not just a family member, an interested party can make an application through TASCAT, through their guardianship administration stream, for the appointment of a financial administrator, and that could be somebody totally foreign to you. Totally foreign, and at the last resort, it can be the public trustee. Okay, so it's all about making decisions for yourselves whilst you've got the power to do so, and appointing those that you trust to do the work. The unfortunate thing about having a financial administration order, as Todd has mentioned, there are significant restrictions on what the financial administrator can do under legislation, and we often see situations where families who have, under the best intention, taken care of their loved ones, their parents, and have done so in a legitimate, compliant, legal way without causing any problems. An application's been made to TASCAT for a financial administration order. There's viewed to be a conflict of interest because the child's acting for the parent, even if there's not, it can be perceived, and then the children are removed from the decision-making process, and unfortunately we're put in the situation of then being a financial administrator with quite aggressive family on one side, a family member in the middle, and we're restricted to what we actually can do because we can't follow the wishes of the family. They had the relationship, they've known their parent all their life. It's the reverse of elderly abuse. They've actually done a brilliant job, but they've been removed from the situation. So make the decision while you can, appoint somebody while you can. Any questions about any of that? I'm moving pretty quickly through these, but yes? Yeah, several. Joint is both parties making decisions. So 2 parties can make the decision, have to make the decision. Severally means that 1 party can make the decision. In the joint situation, yeah, that's right, both parties have to make the decision. Unfortunately, in the several situation, even if you're not involved, even if you don't make the decision, you can be linked to the attorney that has made the decision. Okay, so you need to be aware of what that person's actually doing. Yeah.
With the several, if one of the parties is overseas, then the other party can take over and do the
Yes. Yeah.
requirements.
Yeah. That's right. Yeah. But the person who's overseas, if the one in Australia makes the decision and it's for whatever purpose, a fraudulent decision or whatever, questionable decision, the one who's overseas can still be held accountable for that decision because they've still got an obligation to understand what's going on.
But you've got that.
Yeah. So, and I'm always looking at the worst case scenario there. Yeah, that's right. Half glass full, half glass empty. Yeah, but there's situations that you can put yourself in. Yeah.
So which one are you recommending then? Between the joint and the several?
each case, our corporate solicitor uses the term, each case turns on its own circumstances. So, let's,
They don't take, they don't come to action until they're registered.
that's right, yeah.
So they need to be registered by the person who's cognitively competent.
As soon as you can either register it immediately, or it can sit there waiting for a doctor to provide medical evidence that the person has lost their capacity and they need the enduring power of attorney registered, and then it can be put in place.
So it's initiated by a medical practitioner.
Yep.
But the person who's been protected still has to be able to sign the document at the start.
Right at the start, yeah, that's right. Yeah, good. Anything else? Moving right along. Guardianship. As with power of attorney is a financial document. Guardianship, enduring guardianship, is personal medical decisions. Okay? Where are you going to live if you lose the capacity to make decisions for yourself? Who's your doctor going to be? Who's your dentist? Which hospital you're going to go to? What kind of medical care you're going to have? And importantly nowadays, at what point of time, who's got the decision to turn off the machine? Okay? What it does for people left in that situation, particularly for family members, it gives them some, I guess, peace of mind of knowing what their loved ones' wishes are. As to, well, as hard as the decision is, and I've had to put a pet down, and that was hard enough. I'd hate to be making the decision about what I'm going to do if my parent was on life support and I had to make the decision. But it would be far easier for me to make the decision if I had their wishes in front of me and I knew that that's what they wanted me to do. And that's what enduring guardianship allows you to do. It allows you to, again, as with power of attorney, appoint somebody who is loyal, loving, that you trust to make those decisions. And you can make it either individually or you can make it jointly. You can name 1, 2, 3 people in succession. So that if the first one's not there, the second one can do it, the third one. So you've got some continuity in the decision-making process, but importantly, somebody there to make the decision on your behalf. If you don't have an enduring guardianship, again, it comes back to TASCAT. If you lose capacity and you're unable to make decisions for yourselves, and this is where the narrative has been really driven over the last 18 months about human rights and something we're totally on board with. But if you don't have somebody appointed, then again, an application can be made to TASCAT for the appointment of a guardian. And again, it can be somebody who is totally removed from you. It can be the public guardian. And again, you get into this situation of somebody making decisions who doesn't know you, doesn't know what your religious beliefs are, what your family beliefs are, what you would want yourself. So again, I say, consider it, think about it, appoint somebody that you know, you trust, who knows you, who can follow your instructions, your wishes, and remove it from being in the hands of somebody who doesn't know you. Okay? How? Again, as with the power of attorney document, enduring guardianship document's a legal document. It sets forth exactly the parameters that can be used. It gives you the opportunity to name who the people will be, has to be executed in a certain way, and with the power of attorney, it gets registered. But in this case, it gets registered immediately. Yes, Louise?
Do the names of the enduring guardian need to be the same as the power of attorney?
No, not at all. Not at all. Somebody totally different, probably wise to have somebody different, somebody making your lifestyle decisions, somebody making your financial decisions. But the two should be talking together as to what decision, particularly during the person's life. So let's not write you all off. Let's say that you do need help, need assistance. Let's get people in there who can make those decisions together about what's best for you. Any other questions about that? Finally, wills. Will. I always leave this to last because this is the bit where we do write you off. The bit is the stuff that can be done during your lifetime. We get to see some good effort there. What is your will? Your will deal with all your assets. What are your assets? Anything that you own in your sole name, anything you own as a tenant in common. If you have a private company, it would be the shares in the private company. If you run a partnership, it will be the value of the partnership when you die. If you have a trust, the trust is removed outside. Superannuation may come into the estate if you haven't named a nominated beneficiary or a binding beneficiary. It's up to the trustee of the superannuation fund as to whether they bring the money in. Could be an interest in another estate that comes into your estate. There's a plethora of things that are dealt with under the will. Also deals with funeral. What are your wishes with regards to funeral? Another important thing to put in there for the benefit of the family or for friends who are left behind. What are the wishes? So I can do something with peace of mind. If any of you have got minor children that your partner doesn't know of, gives you the opportunity to name in your will guardians for minor children. Something your kids may need to think about. So why do you make a will? As I keep saying, it's your opportunity to have your wishes expressed, to distribute your estate to those that you want it distributed to. Okay. Keeping in mind that there are very strict legislation, Testator's Family Maintenance Act, which allows people to make a claim against your estate if you haven't appropriately covered for them in your will. So when you make your will, you're making it today for today's circumstances, hopefully for something that won't occur for many years down the track. But when you do pass away many years down the track, they look at your will then for the circumstances at that time. What I've seen in the past is many times where family members or sons or daughters have been left out of a will because they've been given their inheritance or their benefit during their lifetime. And the parents think, well, Joe got his couple $100,000 there, the rest of the estate goes between the other siblings. Not knowing that Joe wasted all the money all the way through and has a claim at the end as a moral responsibility of the parent to deal with each child equally at the time that the person passed away. So when you're talking about estate planning, these are things that you also need to consider. Can I cut somebody out? You can, but what's the impact of doing so? And should I put something in place to cover that? Should I have assets sitting outside my estate, not covered by my will, that go to certain persons? And certainly that's a big one with superannuation. How do you make a will? You could sit there now and write out your will. I give everything to my kids. Bang, sign it. That could be taken as being a legal document. Have to be proven, but it can be taken. You could do a will packet. Go down the news agency or go online, get a will packet sent out to you. Very problematic. I've dealt with estates in the past with will packets that named 3 children as the executors. One child was 18, the other was 16, the other 14. Just caused all sorts of bedlam at the time that the parent passed away, and eventually came to us in another lifetime with another trustee company that I worked with to settle the mess and clean it all up. My advice is always to get it professionally done. Go to a solicitor, go to a trustee company, get the disclosure on costs, understand what the costs are, understand what the differences are between the two. We always hang our hat as a trustee company on the perpetuity of the business. It's there when it needs to be done. It's not an individual that you're relying on to be alive or capable of doing so when you pass away. I say get disclosure on fees and understand what they are, because in my experience, the main complaint that I deal with wills is children coming to us and saying, Mum and Dad would never have made that will had they known what it was going to cost at the end. I wrote wills with Tas Perpetual for 10, 15 years, made full disclosure. Everybody that I wrote a will for knew exactly what the end cost was. We would have those people, those testators sign off on the understanding, but I'd still have children on occasions come along and say, Mum would never have signed that if she'd known what the cost was. It's quite amazing. And it's probably something I'll talk briefly about on what the changes that I've seen over 30 years. So how do you make the will? Get it professionally done, get it executed properly, speak to the person that's making your will and get advice about what impacts the estate, what should be in the estate. If you've got blended families, what the impact is for blended families, stepchildren, children, how the relationships can break down immediately upon the death of the surviving parent, and put in place what you want to happen. The alternative is, if you don't have a will, goes to legislation. Legislation will dictate who the estate is distributed to. Executors, who should be executor? Again, you can name individuals, you can name joint, you can name friends, you can name family, name a professional, in my opinion, depending on what your circumstances are. There are plenty of people that, simple administrations, mum to the kids, but always think about what's the situation you're putting your child in becoming an executor and what the pressures are on them from their surviving siblings. Because where there's the opportunity for money, the green-eyed envy comes in place and can impact you. Very quickly, what's changed in the 30 years that I've been doing this job? No doubt, connectivity. People are connected immediately nowadays and they expect things done. It increases the expectation. When we do things, people expect things to be done immediately and don't understand that there are timelines with respect to administering estates, administering power of attorney, dealing with third parties. Blended families, certainly a big thing to think about with wills, and same-sex relationships have come into the fore over the last decade or so. My final thing would be to say to you, when should you do this? These three. Hockey coach once said to me, failing to plan is planning to fail. If you don't have it in place, there's going to be problems, without a doubt. So get things in place, get your circumstances sorted, and you shouldn't have too many problems, we would hope. Any questions on any of that? Yeah.
How enduring powers of attorney were prepared by the public trustee quite a number of years ago now? We've moved a couple of times. Will they still be valid, or do they need to be updated like the will?
No, there's the address on the power of attorney has no impact with your residence.
I seem to recall that
Yeah.
now wrong.
Yeah. So, yeah. Anything else? No. Well, I'll leave that to... I'm happy to stay around when Todd has to get into Air Force One to head up to Launceston. I'm more than happy to stay around if anybody else has got any other questions. Thank you.
That was really a great session, Rod. You know, Rod's got over 30 years experience when it comes to these sort of matters, so it was great to sort of delve into his practical experience. In the interest of time, I'm just going to pull out a couple of key points when it comes to moving into aged care. It's a significant event in people's lives and it's really traumatic, and in the theme of today's presentation, it's really important to plan ahead, because if there are no plans in advance that have been made and no discussions that have been held with family in advance, and I know it's a difficult conversation to broach, it just makes it all the more stressful for people when it happens, and quite often it can be something that happens suddenly when people face themselves with this move. The first thing that when you move into aged care, or you're looking to move into aged care, the first step is to coordinate an assessment with a member of an aged care assessment team, or ACAT is a term that people may have heard. So that's the first thing. Following that, you need to look at an aged care home that suits your needs, with the number one thing obviously being location. And the third thing is really about your finances, and things can get very complicated. In particular, the impact that it may have on Centrelink, not necessarily at that point in time, but it might be 2 years down the track. And the common thing that people are faced with is what to do with the family home. When you move into aged care, there is an accommodation payment for most people, and in the tune of hundreds of thousands of dollars. And unfortunately, in Tasmania, a lot of people don't have that sort of money just laying around. The number one asset is the family home. So, you can imagine a lifetime worth of memories often, and a lifetime worth of contents have accumulated. And all of a sudden, in a quick period of time, those contents have to be condensed to what you can take with you in a single room. And one of the sad things that we have to deal with when we're actually helping people through this process is actually when you're selling assets and you're going to Gowan's auctions and beautiful pieces of furniture that have a lot of sentimental value, not a lot of value on the market. So we really encourage people to, talk to family, and those special pieces, to give those to the people that you would like to have them, because, you might have $100,000 worth of contents, but if you have to sell it all, it might only bring in around $10,000. That's just a fact of where the market is at. So these aren't the main sort of things that people think about when they go into aged care. They look at, okay, what is it going to cost on a daily basis? All of the detail around the fees and how they're calculated. But it's the emotional side of things that we often have to deal with. One thing that Rod said, which really, I can't reiterate it enough, is it's great to have your documents in place, but talk to your family. Make sure that you've actually socialised what your wishes are. Because that common scenario that Rod spoke about, even though the context that he gave, there was probably a bit of that green heavy coming into play. If you haven't had the conversation with your family, then they do often think, I'm not sure if mum or dad would have wanted that to happen. So talking about it is often uncomfortable. A lot of people are very proud, and financial matters are not something that you always talk about. So we do fully appreciate it's not an easy thing to do, but it actually clearing the air and getting onto it now gives people peace of mind down the track and make things a lot smoother. The other thing I would say is it's really important to get financial advice. And the thing that I wanted to say today is it's a specialised area, aged care. So it's not just about going to any financial planner. You might have a relationship with a financial planner who's looked after your retirement funds, but they will tell you that doesn't mean that they're a specialist when it comes to aged care. And they may often refer you to someone else, because you need to be constantly doing these sort of scenarios to get very competent and stay across the changes. Whenever we're acting for people, we get independent financial advice. It'll come back, it'll show all the numbers around what's in the client's best interests. We look at whether to sell the house, retain the house, whether it's better to rent it out, what the impact it has on their aged care fees. So again, really important to seek financial advice. The other thing is that when the time comes and you do have to sell the family home, if that's what you're faced with, it's really important about what you actually do with the proceeds. So there are some opportunities out there. Downsizer contribution is something that's worth looking into. It's where you can pay up to $300,000, subject to you meeting the criteria, paying that into superannuation. Quite often is very favourable from a tax point of view, and as well as your fees that you're paying in aged care. So again, this is something that we seek independent advice on. Yes?
An age limit on paying into superannuation?
There is traditionally, but this is where that particular strategy opens it up for people. So we had an example recently where the client was 80, and that's past the age that you can traditionally contribute money to super. But because they'd sold the home, they had the opportunity to pay money in via this downsizer contribution. Okay, well I might, is there any people that came here today with a burning question about aged care that they would like to ask before we sort of look to wrap up? If not, as Rod said before, we'll be sticking around for any particular questions. So I just wanted to say thank you for coming along today, and we might just break now for any questions about anything we've covered off today or any questions that people have. Yes?
If you're not on an age pension, what's the amount that you have to contribute when you're moving into aged care, and what's the cost, or is it is it asset-based?
It varies. So one of the things that I was going to mention earlier on is it's really important at the start that you do what's called an income and asset assessment, because that will determine, based on your individual situation, what you are required to pay, both from a accommodation deposit or a RAD as they call it, as well as the daily fees that you'll pay. So it's different for everyone and it's different for each provider. One thing I did want to say as well, that the flip side of that is the government does have a safety net and a provision for all Australians. If you don't have assets or a home, then there are spots for people as well moving into aged care.
So who does that assessment? That assessment, who does
Just so everyone can hear the question, there we go.
So who does that assessment? Is that like a tax team, or is it a financial planner, or is it the actual aged care?
No, it's a government department. I'm just having a look through my notes for the actual name of that. Just while I'm doing that, Centrelink is a really good resource as well for moving into aged care. And I've written down here sheepishly, if you need more information, contact their financial information service on their 1300 number. But I suggest that I suggest you make yourself a cup of tea and maybe have a packet of biscuits there, because the wait can be quite long. I might take that question offline. I'll have a look through my notes and provide the answer as to whereabouts that is.
That number's on the slide.
Yeah, My Aged Care is another useful website as well for people. Any other questions? Yes. Oh, sorry. We'll let Maria give you the...
Microphone here, and then everybody can hear the question.
Is there any seminars held on moving into aged care and the different requirements?
I'm not sure if there are in Seniors Week. From time to time...
None in Seniors Week, but are there any places that run those?
I'm not sure. I think, I'm just trying to think back. From time to time, certain financial planners will hold a seminar, but I haven't sort of seen anything that is regularly being held. Most of that information now is held online for people to sort of scroll through, as opposed to this sort of format.
Okay.
Any other questions? Going once? Twice? Okay, well, thanks for those questions. And in closing, I really hope that you've got a better understanding now at the end of Rod and Al's time as to when you came in today. We really find that people are still, apathetic when it comes to estate planning. So we would encourage people not to put things off any longer, whether that be preparing your documents or even reviewing them. Do that by making an appointment today. For any seniors or pension card holders, a reminder that you can make a standard appointment at the Public Trustee for a will and enduring power of attorney free of charge when you appoint the Public Trustee. So, that concludes today's events. On behalf of the Public Trustee team, thank you very much for coming along today. And morning tea. I'm looking at the back. I was about to say morning tea served, but I'm seeing some empty tables, so can't be too far away. So I think we've got some... yes, grab a coffee or tea. Thanks, everyone.